It's Lisa from Been There, Got Out. And today's guest is a New York City attorney, a family lawyer that I actually had the pleasure of meeting with in person and told her that we need to talk about something. There she is. That is a constant issue in our community. Why are they such a problem? So, Leona, I see you. Worked. So glad. All right. So thank you so much for coming on. I was just saying that we met in real life, and it was great that we met a couple of times and had some conversations. And you seemed like you knew what you were talking about when I was explaining about our community and our clients who are all dealing with really high conflict divorces and post-judgment issues. So before you even introduce yourself, Leona, can you just say, what is a parenting plan for those people who don't know what it is?
All right. So a parenting plan is the agreement that basically specifies who will see the child or children when.
Okay. And now tell us who you are and what makes you good at your job. And then I'm going to start hammering you with questions about airtight agreements and how to write a bulletproof parenting plan.
My name is Leona Krasner, and I'm managing partner of Krasner Law, a family law firm helping folks in New York and New Jersey with their family law needs.
Okay. So when should someone start thinking about putting a parenting plan together?
I would think about it when the going is getting rough, right? You're still potentially with this person. It's not really working, and you're envisioning the future. It's real easy to get in your head, have the scary monsters sort of take over in there. My advice is think about what the perfect plan would look like. Write it down on paper with a pen is wonderful, in the notes app, in a Google email that you either email to yourself or save as a draft, but write down what you want, not just pick up days and times, right? But also location. Where are y'all dropping off the kids or child, right? Is it drop off at school, pick up from school, so that you really never get to see this person very much anymore at all, right? Or something different? Are you all dropping off at one person's house? Does the person dropping off the kids do the dropping off and then the other person need to drop off? What exactly is it going to look like? What is the commute like? Do you all want to meet somewhere in the middle? There's distance. They live a couple counties over, a couple states over, or even in a different country. What's that going to look like, and who's going to pay for it? And who's going
I
to
was
be
about to
there?
say, who's going to pay?
Exactly. Who's going to pay? These are all things you want to think about, right? So that's smaller step, right? And in addition, you want to think about what vacations are going to look like, right? We're talking, you know, Christmas, Hanukkah type break, right? So holiday break, midwinter break, spring break. What is happening in the summertime? Do you each want a week? Do you each want 2 weeks? Is that an absolute no? Do you want your kids in summer camp? Right? What is that going to look like? And then the days off from school, if the other party is open to it and you're open to it, what is that going to look like? Right? So all things to consider.
Yeah, and I'm thinking, what about even just family traditions? Like some people don't, it's not just the regular holidays that everybody thinks about, but certain cultures have different holidays, or certain families have like a family reunion every July. Can you put things like that into your parenting plan?
1,000,000%. So part of this is think about which holidays are the most important to you. Okay, which ones do you celebrate every single year? Which ones are less important, but you still would celebrate them? Which ones do you not celebrate at all, but the child or children still get off, and you can kind of use as a bargaining chip? Listen, I want this, I'll give you that, right? All things to think about.
Yeah, so definitely bargaining and leverage is going to matter, hopefully, because we fingers crossed that you can get parts of this done outside of court in a settlement, because then you'll have a lot more power. So one of the things that we get questioned about is where these parenting plans come from, because most of the time clients don't imagine that they will be the ones putting something together. They're like, oh, my lawyer will do it for me. If you just do it for someone, like, where do you get these ideas for parenting plan? Where do you start as an attorney?
Well, I have old ones from other cases, right? So I use those, right? But, you know, it may be that if you check the court's website, they may have a sample for you to use. Frankly, you can Google it.
Hmm.
Okay. Different different counties, even different states have different laws, but at the end of the day, right, a parenting plan is a parenting plan is a parenting plan, right? Someone will be dropping off the children somewhere at some time. Like, it's a fairly logical, straightforward portion of the agreement. Do you know what I mean? So use logic. It should not be an emotional thing. It's not an, if you are nice to me, I will no, 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 no. It from Friday, pick up from school, to Monday, drop off at school on alternate weekends, beginning Friday, August 9, 2024, et cetera, et cetera, et cetera, right? It's not emotions. It's why don't you love me anymore? No, 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 no. You're making a plan as it relates to your child or children here. So that is really, we need to put on that hat as we consider this part.
Now, you haven't mentioned legal decision making. Can you talk a little bit about that? Because there's a schedule, but then there's the power about major decisions.
Certainly. So I'm going to go a little bit broader. There are two varieties of custody: legal custody and physical custody. Now, I'm coming at this from a New York and New Jersey attorney's point of view, since those are the places where I practice. Okay. So legal custody has to do with important decisions. So we're talking important medical decisions, important education related decisions, extracurricular decisions. Are we putting them in soccer? Are we putting them in equestrian, horseback riding, whatever, that religious decisions, other important decisions, what school or schools the kids are going to go to, summer camp, braces, those kinds of things. Those are examples of important decisions. So there is sole legal custody, where one party gets to make those important decisions. Sometimes they need to consult or speak with the other side. Sometimes not. Sort of depends. There is joint legal decision making, legal custody, which is you all need to talk together and come to an agreement together. But what if we don't come to an agreement,
That's the
right? So
not what if, it's the when in our
when
community.
we do not come to an agreement, what happens? There need to be provisions in there. So if you're considering joint legal custody, you might want to throw in there where, after a meaningful consultation, if there is still no agreement, then the mother has final decision making authority, for example. Okay. You want to put in exactly who has that final decision making authority, meaning they get to make the decision on their own, but they need to talk to the other person first. There are varieties of things you can do instead. You can say, in the case of a disagreement, we can go to a parenting coordinator or a mediator, and that person is going to make the final decision. That's expensive. It's an option, but each time you have to go to these people, they cost you money.
Hmm.
Say that in the case of a disagreement, after meaningful consultation, you go to kind of the expert in that field. If it's a medical issue, you go to the kid's pediatrician. If it's a psychological issue, you go to the child's therapist. If it's an educational decision, you go to the child's teacher or guidance counselor or somebody like that. If it's a religious issue, you go to the religious authority in their place of worship, the priest, rabbi, whatever.
Yeah. So now, legal decision making in our community is a really big deal. And often people come in and they're like, I want sole legal. Now, in our world, that is very hard to get, especially if you go to court and it's just divorce process. It's not post judgment. So you don't have a long pattern of someone's bad behavior to show why you deserve to get it. But at the very beginning, what's your experience with someone saying, I want sole legal, my ex doesn't agree to that, and I'm still going to get it? How hard is that?
Very, 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 very hard. Okay.
Right.
Really, really hard. We're talking many tens, if not hundreds of thousands of dollars in counsel fees where you would likely lose. So here is what I counsel my clients in New York and New Jersey, right? So you can say it's joint legal custody with final decision making authority. So the other party, oh, look, I'm getting my joint legal. I still have a right to my kids. Yes, yes, is what's going on in their head. However, your decision rules, right? So you need to chat about it. right? You need to let the other side know, and you should let them know in writing, text message or email. Pop it in there. Oh, she never told me. Yeah, I did. Look, such and such date. Bam. Here you go, Your Honor. Right? So keep a written record, but if they don't agree, then screw them. Your
Yeah.
decision still rules. So is it the I won, I got sole legal custody? Not exactly. But for all intents and purposes, it is really, really similar because you get the final decision. Either the other side agrees with you or not, but it doesn't really matter so long as your decision is fairly reasonable, right? If you make sole decisions that, cost, to put the child into, say, a program that costs $100,000 and each of you make $20,000 per year, the court will likely find that to be unreasonable, right? So it needs to be something that's reasonable, but so long as it's a reasonable thing that you're talking about and the other side says no, if you have final decision making authority, it's what you want is going to go forward.
Right. Yeah. Yeah. And we talk about that with our clients too, but getting the tiebreaker is still really hard. Like some people, like in my case, I did what you recommended, even though I didn't know you back then. And I was also advised by the meter, let's put joint in, but you have final say. So it's basically like you have sole. And again, of course, we need to have significant consultation, but it's still really hard to negotiate for tie breaking. You know, you can change the language and we fluff it up, but that's not an easy thing to
No.
get. So people should just know that. What are some other mistakes or misconceptions that you see that people have about parenting plans or just, custody?
I think the key is to be as thorough in the plan as possible. It's very easy to be like, oh, well, we've been doing this forever, so I'm not going to throw it in.
Mm,
Throw it in, even if it's little, right? If Grandma Sally's birthday is something y'all always celebrate with the children, put in Grandma Sally's birthday. If there's a reunion every year, put it in there. If you've got, your sister's property in the Poconos that y'all visit 6 times per summer, throw that in there, right? Be thorough in the sense that where possible related to the parenting plan, relating to, seeing the children or something relating to the children, it's better to put it in there. What I mean by that is not the touchy feely emotional pieces, which are very important, right? You should be working through those on the side. They have no bearing on this agreement.
Give me an example. What's like the touchy feely squishy stuff that often people might say, I'm putting this in the parenting plan.
So something that people like to put in there a lot is restrictions on when a party can introduce the child or children to a new significant other. Some
Mm-hmm.
people want to meet them, go to a meal with them, inspect their person, do a background check, check their car, check their room, check under the mattress. No, I know you want to do these things. I know you want to size up the competition. No,
Yeah.
okay? So it's one thing if you and your ex agree, oh, they need to date for at least 6 months or something like that before the children could be introduced to this person. The courts don't take much of a position on new girlfriends or boyfriends. They just don't. They're new girlfriends and boyfriends are kind of a fact of life, right? Unless there's something really weird going on. And I've seen weird things, right? Unless the other partner is sleeping with or having loud sex in the other room and the poor kid's on the couch, maybe with another kid. Seen that. I mean, heard about that, right? From clients, right?
Yeah.
Unless there's sketchy stuff going on, unless you've got the child in bed with the new girlfriend and the ex, right? We cannot, unless the other side agrees, ask for all of these things that on a personal sort of painful level you might want to know about the ex. And what's the ex's full name and their address, how many children, social security number. No, those aren't things. Those are not things that a court would ever grant, ever, almost.
Yeah. Yeah. Good to know. So I love that you and I are both from New Yorkers, and we call it the harsh New York reality check. Better to know now than to spend lots of money
Yep.
putting it in and it's unenforceable. So speaking of that, one thing that comes up a lot is the right of first refusal. So I'm going to withhold my comments on what we've seen, but what do you see in terms of that being enforceable in court? And actually, can you just say what it is? Because some people might not know what the right of first refusal is.
So, right of first refusal. So, let's say I need to be sending my child to my ex's house, except he is working that day. Okay? If he's unavailable to personally watch our child, and there's a right of first refusal provision in the parenting agreement, then I get to hold on to my child, and dad doesn't get the child on that specific day. Now, you get to be very specific. You get to say, so long as one party is unable to watch the child for a period of 8 hours or more, 6 hours or more, to one day or more. You throw in exactly what that looks like, then, the other party may exercise the right of first refusal. Now, you throw in obligations, requirements, right? If one party will not be able to watch the child for a period of whatever you all agree, they must send a text message to the other party alerting them of that fact, right? So you want to throw in as many particulars as possible. Does this include if he has a nanny while he's working? That depends, right? What's in your agreement? Do you want it to include the nanny while he's working or no? Generally speaking, the whole idea is the parties want for only the parents to be able to watch the kid if one of the parents is not going to be available for a prolonged period of time. Now, I'm not talking 30 minutes where like the cousin watches the kid while you go to the grocery store and pick up the milk and eggs. I'm not talking that, right? It usually needs to be several hours or a day, something like that. And
Yeah.
is that it isn't a caretaker, it isn't a nanny, a babysitter, a grandma, an uncle watching the child or children.
Yeah. So what we've seen often is there's a right of first refusal put in, and then it's not really that enforceable because if someone says, well, my ex one time went out for the night with their new partner and they didn't tell me, and I should have been able to watch my kids, what do you think a judge would say to that if they take it to court and say, but they didn't honor our right of first refusal?
One time, right? So here's the thing, judges are looking for a pattern, right? At worst, likely, the person who didn't let the other person know, the party who didn't let the other party know, might get a quote unquote slap on the
Mm-hmm.
wrist, right? You should have told them, but we're not changing it. Going forward, ensure that you do what you need to do, case dismissed. Like, it is unlikely unless you have, I would say, at least three, examples where you have proof in writing, or somehow that you can prove it, right? Because then it becomes a he said, she said, right? Oh, he was with the new girlfriend. Oh, yeah, prove it. Oh, well, I can't. My kid told me. Yeah, right? So you need to sort of document this in order for it to stick.
Yeah, and I'm also thinking, how much could that actually affect a change in physical custody? That's that's what I thought. It's like, so what's even the point?
So in New York and New Jersey, you need a substantial change in circumstance, right? Going out with the girlfriend. Now, here's the thing. You leave the child at home by himself or herself, and this is a young child, a dangerous situation, that might rise to the level of substantial change in circumstance, right? Somebody is watching your child or children while they go out on a date, violating this. It is most likely not going to effectuate a change in custody.
Right. So that's one of those things, like you could put it in the parenting plan, but it's really hard to enforce when you think about what are the goals if you go back to court when it's not adhered to, nothing's really going to happen anyway.
Agreed. It's more of a protective measure,
Right.
right? The
Yeah.
idea is that most of the time, hopefully, if the other party signs this thing, they'll let you know, right? If they're going away on a vacation for a week, or they would have left the child with their mother, now they'll think twice before doing that and not telling you. A week's a long time, right? So it's more of an enforcement measure as opposed to, oh, got you, you failed one time, no more custody for you.
Right. It's like a gentle nudge to behave properly.
Precisely.
Okay, so one of the issues that we see that actually the number one thing that ends our clients back in court, they end up back in court, are parenting plan issues that have gray language. Why is it so important to have airtight language? And what are some things that we really should be paying attention to?
Got a case right now. Leona, parenting time plan says Martin Luther King celebration. Guys, does that mean a day? Does that mean a
Mm,
weekend? What is a celebration?
right,
You need to throw in there, right? For any and all, if this is what you want, weekends whereby the child does not have school on Monday, whichever, for example, whichever parent was to effectuate parenting time between that Friday and Sunday shall extend their parenting time through Tuesday drop off at school when the
right.
child on Monday. Did you notice I was very thorough
Specific.
and tight and specific? Review it. Better you read it out loud. Read it bottom up, right? We understand in our heads. We think we completely. It's so clear. Martin Luther King celebration. Not. Have somebody else read it and make sure that we're super clear. Name days of the week. Name pickup time, day, drop off, pick up, who's effectuating where, always, including for holidays.
Yeah. I mean, um, so my partner Chris is an expert in writing parallel parenting plans. And so what he does is he'll write them, but also review parenting plans that our clients come over, and he looks at it as someone who will try to weaponize it. He reads it with an abuser's eye, going, how can I play with this language?
Yep,
And it is really helpful because there you find these words where it's like, this is not defined though.
yep,
What does this mean? And we always watch for the word reasonable. Like,
yep.
oh no, we're going to have different interpretations of the word reasonable. So, if at all possible, to really specify no reasonable, because reasonable to me is not the same to my ex.
Correct.
And we often find that words like that can be weaponized. And that's why people are like, but it says this, or there's no consequence. So, speaking of that, consequences, like this is a huge thing that we wonder about when somebody violates a parenting plan. What are some consequences that can be written in to make sure that it's enforced? Because it's so much easier to get enforcement when you have that clear language that signals to the judge, this shall happen. I know it's used, this must happen rather than may happen.
So shall is an important word. So for example, say you've got somebody who rolls up 30 minutes, an hour and a half late, 2 hours late, just comes and goes whenever they want, right? You throw in there that each party has a grace period of up to 15 minutes, whatever time you want, but there needs to be some grace period because traffic is a real thing, okay? Up to 15 or 30 even minutes to drop off or pick up the child. If the party who is coming to pick up the child is more than 15 minutes late, then and then think of the consequence you want, right? So if the person picking up is the person who has primary custody of the children and the kids sleep there more nights a week than at the other parent's house, then that visit perhaps may be forfeited and no makeup visit shall be given so long as no warning in writing was provided. I mean, things happen. Like
Yeah.
we've been there, right? Sitting in traffic and you're like, oh my God, right? So as long as a warning is provided, you can't really revoke it. I mean, as long as I'm using the word reasonable, right? Here's the thing. If the left that 2 hours late, hey, I'm late, I left late, right? But if there was a 7 car accident, God forbid, on the highway, right? And there are traffic delays, that's not really the other person's, you know, they didn't do it. It's not their fault,
Yeah.
right? So being clear about what will happen. So either forfeiting that visit, forfeiting the next scheduled visit. Usually that's what's used sort of to respond, to quote unquote punish, if you will.
Mm. Okay, so let me give you trickier ones because that's not usually the big issue with our community. Ours is violations of legal decision making, where they have joint legal decision making. There has not been significant consultation, and one person is like unilaterally doing these things, and the other parent is completely left out, and they're like, what am I supposed to do? Like, it's not enough to flip legal decision making, but that party's like gone rogue and they're just doing all kinds of things and acting like the only authority. What recourse is there for someone whose ex violates legal decisions making?
Got where you've got a party who is repeatedly violating joint legal decision making, couple things, right? So if that person is signing up the kids for all kinds of different activities, you can throw in language saying for any and all activities that are not mutually agreed upon in writing, with text message to suffice, for example, or email, whatever you want. Um, the party who signs up the children for that activity, it will be responsible for paying 100% of the costs of same.
Okay. Let's say
So,
they do it on the other parent's time. They're signing them up.
mm,
This is another common thing. So I'm signing in our kids up for soccer, and it's on your days too, but it's in our children's best interest because they love soccer. So they're going to have less time with you, but it's in their best interest because they'll have more friends, etc.
not
And then the parent who doesn't get the time, who's like, wait a second, I don't want the kids to go to soccer. It doesn't matter if you pay 100%, but like I don't want someone scheduling on my parenting time, and it says you're not allowed to do that, and now I'm stuck in this mess because the kids are excited. Like, what do we do?
neither party shall, without the consent in writing of the other party, sign up the child or children for any activities or extracurricular activities during the other party's parenting time without written agreement regarding same.
Okay, and they've done it anyway. Is there any recourse you can think of? Because this is the stuff we deal with all the time. We're like, let me ask a lawyer what they do.
Uh,
Because it doesn't rise to the occasion
going
of
to court.
changing anything.
Why are we here talking about soccer? Like, really? Come on, guys. The judge won't care.
I
Sorry.
know.
Right?
I know.
If this violation occurs, then the parties must either go to a parenting coordinator or to a mediator. Pick one.
Mhm.
Don't have both. Pick one of those. And full costs of same shall be borne by the individual who violated this provision.
Oh, I like that. That's a good one. All right, great. Let me think. Anything else regarding if someone knows, because our community is this, if someone knows that this is a difficult situation, they're putting together a parenting plan, are there other provisions that you feel like, ooh, make sure you put this in there? For example, what do you think about a non-disparagement clause?
Must,
And first, can you explain what that is,
absolutely.
just in case?
A non-disparagement clause, basically in plain English, says you won't say yucky stuff about the other party to the child or in the presence of the child to a third party. Okay? So that's critical. That's really, really important. I throw in there that you all agree not to post nasty stuff about each other on social media. Not using that language, of course, but
Mhm.
no posting bad things about one another on the internet. Okay? Very important. Sounds like somebody who's watching us agrees. Very important. Also, what's critical is language that says that neither party shall discuss this case
Mhm.
with the children. Shouldn't be
Can you,
discussed children. It's critical because next thing you know, there are adult issues going on and that are discussed in the case, and it's an adult case, and one party shows the child or children like examples or proof, God forbid, of infidelity, for example. Got a case like that. Those kids want nothing to do with that parent. That relationship is all screwed up, right? Adult stuff needs to stay adult stuff, in my personal opinion. All right. So a provision that says that no discussing the case with the child or children, very important.
okay, so that's something that happens all the time in our world, which I think I told you the book that we're working on now, as well as this online course, has to do with one parent trying to turn the kids against the other parent in these high conflict cases. Let's say there's a clause in there, a non-disparagement clause. but the other parent does it anyway. I feel like this is something the courts can't really deal with because what exactly is this the punishment? Or as an attorney, what would you ask for when you see repeated violations where the case is being discussed with the kids, there's a visible impact on the child where they're getting anxiety, they're regressing, they're wetting the bed, their grades have gone down, suicidal ideation, whatever, and you can see how the kid is taking in all of this conflict and all of this knowledge that they shouldn't have. Is there anything legally that someone can do
Yes.
about this when they watch, they're witnessing and they're like, oh my gosh, my kid is really suffering and I'm not talking about my ex keeps involving them in the conflict.
Get as much proof as possible. All right, proof is king. He said, she said, these cases are over. Do you know what I mean?
Mm-hmm.
As much proof as you can possibly include. And then you throw the kitchen sink at the other side, right? So this is a violation of the agreement. You're looking for enforcement. You're stating that there's a violation. You want sanctions. You want sanction in the form of fines. You want prison time. You want counsel fees. You want change of custody. This is serious. This also means you're likely going to need to hire an expert. You need to come at this so strong or a judge is going to throw you out of the courthouse.
Wow. What kind of expert would someone, I mean, I know, but I want you to say it. What kind of expert would somebody hire in a situation like this where that you see that the kids are going to be affected?
There are experts as, so the term alienation,
I know.
term that really pisses off the court for some strange reason, okay? Because it's thrown around a lot and the courts really are not equipped with how to handle it. But you're looking for an expert around the subject of alienation, if that is what is occurring here, okay? Happy to discuss offline ones I recommend. I have a huge hunch that, Lisa can assist with that as well. So, yeah.
Great. I mean, awful, but thank you. Yeah, that we because we see this all the time. It unfortunately comes with the territory of high conflict divorce and post separation abuse. So, Leona, any other things that people should really think about when they're putting together a parenting plan that they know it's going to be a difficult situation and the anger probably won't subside?
There's something called the Child's Bill of Rights, and it talks about, basic kind of rights, quote unquote, that children ought to have. Frankly, New York and New Jersey courts enjoy the inclusion of this. If this is a high conflict type relationship where all of these are going to be violated again and again, it's only going to strengthen your case if and when you need to go back to court. And then number one was violated 63 times on the following dates. Let me describe. And item 2 was violated 27 times. Please see below for the dates, right? Where you are so meticulous. I mean, this is like a Dear Diary situation on steroids, okay? Where
Wow.
you're down everything. I recommend using like a Google Doc or a Google Sheet so you can update and you don't have 87,000 versions of the document in your possession. It just updates as you go.
How common is the Child's Bill of Rights? Like how many states have it, or do you know other countries who have versions of this?
I can only talk about New York and New Jersey.
Yeah. Okay. All right. Well, good to know. I imagine that we're not the only states who have anything like this.
Correct.
Yeah.
I don't know. I
Yeah.
would imagine that kids, there's some sort of equivalent of a kid's Bill of Rights in other places. I don't want to say since I don't know for sure.
Yeah. All right. So people watching this now and later, make sure you research Children's Bill of Rights or anything like it for your state or country. And that is so helpful, Leona. I'm thrilled. This is new to me.
Yay.
I've heard of it. I didn't know how it would apply in these cases, but it's great to have any kind of defense to nip this in the bud because we know the impact it has on children and conflict has on children short term as well as long term. So even if you're dealing with a difficult adversary, you want to do what you can, what's in your control to try to reduce the conflict as much as possible and protect the kids from it. So Leona, thanks so much. How can people find you?
Please feel free to reach out. My number is 917-589-6519. My email is Leona, Leona, at Krasner, that's LKRASNER.com. And then I do free consultations. If you want to chat, I'd be happy to chat.
Oh my gosh. You do free, lawyer does free consultations? Okay, remind people again where you are, like what states you do.
Yep. So I do New York and New Jersey.
Great. All right. Well, I so appreciate this. And I'm sure I'll see you soon, Leona.
Sounds wonderful. Thank you so much for having me.
Okay,
Have a great day, everybody.
you bye.